Full Bloom is brought to you in part by the following. Welcome to Full Bloom, the award-winning show that celebrates life. Here's your host, Zita Christian.
Hi everyone, welcome to Full Bloom. I'm Zita Christian. You know, aging is a fact of life. It brings challenges, medical challenges, most importantly, and for many of us, also financial challenges. Tonight, we're going to talk about some of those challenges and, more importantly, about some planning you can do to help meet them. With me are two attorneys from the law firm of Pitney. First, to my right, partner Dane Dudley. Welcome to the show, Dane. Glad you could make it. And to your right, Rebecca Iannantuoni, an associate at Pitney. Thanks very much for being here tonight as well.
Thank you.
So Dane, there's a lot to cover here, and I don't want to waste time, so I want to just jump in, get in with the heavy stuff. And let's start with that whole concept of being incapacitated. That's a pretty broad topic, very important one. And can you kind of narrow that down for us?
Sure. What we are talking about today is planning for those situations where someone can't act on their own behalf. So it could be a medical issue, it could be a financial issue. And as we've talked about, it's something that everyone has to plan for. So anybody who's over 18, who's an adult, needs to worry about these kinds of issues. It could be a situation where they are in a car accident or they have a medical issue and they're not able to communicate their decisions about medical care, or they're not able to take care of their financial needs. And it's that kind of topic we're going to talk about today.
So this isn't what I understand, a lot of people, lay people, think of the topics of estate planning and looking at disability or long-term care under the umbrella of elder law, but it's not just elder, is it?
No, it's not.
Not at all.
It really can touch everybody, and I think we'll be talking about some of those topics tonight, that it can affect children, adults. It's a broad topic.
All right. Well, in keeping with this very difficult concept of being incapacitated, why should I, at any age, why should I be thinking about that? I mean, if let's say that I'm 18, young and healthy, and why should I even be thinking about that?
Well, we don't know how long you're going to be healthy. We don't know how long you're going to live, unless you can tell me now what your plans are. Right.
I have it planned.
You just never know. The proverbial bus is around the corner, and we just don't know. This day and age, you see all sorts of news reports about people in accidents or people who have an illness that suddenly strikes them, 30-year-olds, 40-year-olds who have a stroke or something that impairs their ability to make those kinds of decisions. So you just don't know. And what our job is to help folks plan for that when they are healthy and they are able to make those decisions, and they can plan ahead for those events that hopefully never come, but most likely will to some folks, and you just have to be prepared.
Well, what kind of things would I be planning for? I mean, in the idea of planning in case I'm incapacitated, what does that involve?
Well, let's take an example.
Okay.
Oftentimes when folks go into a hospital, they're asked to fill out a lot of forms, and some of those forms have to do with these kinds of issues. Who's going to make a medical decision for you if you're not able to make them yourself? In Connecticut, you can sign forms in advance, whether you're going to a hospital or not. They're typically called advanced healthcare directives in Connecticut. And what that document does is it allows you to make decisions for your own care now while you're conscious, capable, healthy, and they can deal with issues, for example, end of life, a living will, that's often talked about. That's the ability for you to say to your family and your loved ones, if I become so ill, if I'm in a terminal condition or permanently unconscious, don't keep me alive just to keep me alive. And that's a very important thing, because if you don't have a document like that, your family is left wondering, well, what would mom or dad or brother or sister want to have happen in that situation? So that's one of the circumstances, the end-of-life type of thing, communicating that to your loved ones. Short of that, if you are in a car accident or you're ill or some other way incapacitated and unable to communicate, and let's say you're lying in a hospital bed and the doctors need to have permission to have a procedure, blood transfusion, operation, they have to find someone in the family who's authorized to make those decisions. Usually, if there is no documentation, it's going to follow a certain line, spouse, parent, sibling. those would be the people the doctors would look to. If you want to have control over who's going to make those decisions, again, you need a document like this Advanced Healthcare Directive that allows you to name the person that you want to make the decisions for you.
Because I'm seeing, just by chance then, if there is no directive, someone might be making a decision for me, some person I would not want to be making the decision.
Mm-hmm. It could be someone who doesn't see eye to eye with you. It could be someone who doesn't know you as well as you'd like to have involved with the decision.
Or if I were writing a suspense novel, it could be someone with an ulterior motive.
Sure.
Oh, okay. The plot thickens. Well, so I would think then the rewards for having a plan like that would be peace of mind, for one thing.
Definitely.
Yeah. And the consequences, obviously, that someone else might be making the decisions. Or is there also a situation where that there's no decision made? I mean, is that ever the case?
Sure, and that's one of the risks that we always talk about with clients is if you can't make up your mind and you leave it to a group of folks. Let's say you have no spouse or your spouse has passed away and you have multiple children and they can't agree on what needs to happen. Then you're left with the risk that a hospital or doctor may not be able to perform the procedure if everyone's fighting about whether to do it or not. We always recommend that people try to identify one person, and if it's spouse, wonderful, and if we need to back up to spouse, which we always recommend a backup person, usually it's one person, maybe one child at a time would make the decisions for you, so that you don't have that situation. There's going to be one person who's in charge, they make the decision, and hopefully you've communicated to them what kind of things they should think about when they make those decisions for you.
Geez, Dane, right off the bat I'm thinking, this is an emotional minefield of things people have to think about. Oh, okay. So, Rebecca, I'm going to switch gears here for a minute. I don't think it's going to get any less emotional, though.
Not happier.
No. Let's talk about long-term medical care. Mm-hmm. What kinds of things should I be thinking of when it comes to long-term medical care?
Sure. I think there's kind of the old healthy, wealthier, wise adage when thinking about long-term care. If you are lucky enough to be healthy enough to not have to worry about your long-term care, then that's fantastic. As Dane kind of expressed, it's not completely likely in all sorts of situations. The wealthy is, if you have sufficient assets to be able to pay for your care for your life, then and meet your estate planning goals, then that's a wonderful luxury that not many folks have, certainly in the financial climate that we're going through. And then the other piece of that is wise and being, what kind of planning can you do for your own long-term care? And that brings into two areas that we see a lot, which is long-term care insurance, and we also see kind of Title XIX planning. And long-term care insurance is its own beast. It has a lot of idiosyncrasies, and you really do need to work with a long-term care insurance specialist or somebody who really practices intensely in that area, because there's a lot of pitfalls and you could be sold a product that doesn't necessarily accomplish what you would hope for yourself.
Well, what kind of things do you look for?
Well, when you're contemplating a long-term care policy, a few of the things that you want to make sure, and I don't know if you know how long-term care policies work, basically what happens is you're insuring for a provision of care, custodial and medical care, when you can no longer do certain things for yourself. So usually a long-term care policy will kick in or take effect once you can no longer do certain activities of daily living. And those include simple things like dressing, hygiene issues, ambulating, feeding, certain things that you and I take for granted now, being healthy and well. You start to lose. When you lose those, that's when your long-term care would take effect. So you want to make sure that a long-term care policy has a broad range of activities of daily living that you have to have deficiencies in, because that's really the criteria for when the long-term care would kick in.
Oh, okay. All right, that makes sense. You wouldn't have something that says long-term care kicks in as soon as I can't walk, because there may be many other reasons to have care.
And the other thing that you want to look at too is a lot of the times, so you would need a doctor to fill out a form, the claim form for your long-term care insurance, that says, Zita no longer has the capacity to do these certain things, these certain activities. And then there's an elimination period built into a lot of policies that even though you're otherwise meeting the criteria of eligibility for the policy, you haven't lived out the elimination period for the benefits to kick in. And so your premiums are usually calculated based on the length of that elimination period. It's usually 30 days or 60 days or 90 days.
And do you pick? I mean, do you get to pick?
Well, that's one of the considerations that you look
Okay.
at when you're choosing your premium. So perhaps a $5,000 a year premium might have a 30-day elimination period, whereas a $6,000 a month premium or year premium might have a 0 elimination period. So these are all things that you want to look at.
Okay.
Another big thing you want to look at too is the stability of the insurer. You want to make sure that, especially with what we're seeing happening in the financial climate now, you want to make sure that that insurer that you're paying $5,000 or $10,000 to a year is going to be around when you actually need the care.
All right, well, based on what we've seen here this past year, how do you know, without that crystal ball, how do you know an insurance company is going to be around? That's a gamble in itself.
It is, and you know, that's why we recommend always that you work with somebody who really knows long-term care, not somebody who does it as a piece of their work, but somebody who's really embedded in the system and the programs that are, the products that are out there.
Okay. So what about a person's lifestyle?
Mm-hmm.
How does that factor in? How important is that in picking long-term care? Or are they all pretty much the same? Do you pick care if you want a certain lifestyle? Do you pick care based on the amount of money, or are there certain items of coverage that are different? I'm not quite sure what I'm asking, except I know the end result I want to get to.
Do you want to tell me?
Well, yeah, for a person who, let's say for a person who enjoys traveling or enjoys some kind of studying, or I don't know, depending on the activity.
I think the differentiation is that long-term care insurance pays for medical and custodial assistance, really. So it pays, a custodial long-term care policy is going to pay for a long-term placement in a nursing home, a skilled nursing facility. You know, medical long-term care might provide 10 hours of nursing assistance in the home, in a home care-based program. We're not dealing with long-term care. Long-term care isn't going to be like a financial annuity payment type of thing that's going to provide you with the ability to take trips. The other thing too is that when your long-term care takes effect, when you satisfy this criteria, long-term care by virtue of definition really is that you're not likely to recover from the condition that you're suffering from, and that really what's facing you is the long-term care, the kind of decline, not a rapid, but a decline that you're going to face that's going to end in death. It's not something that you don't tap into a long-term care benefit because you're going to rehabilitate or rebound. You're looking at this as your end of life.
Okay, so
medical care.
Well, it's a jolly topic.
It is.
So but you know, I can really see this is so necessary. I mean, these are hard topics.
They are hard
I think to
topics,
talk about it, and I laugh about it because it's uncomfortable. But
it is, but
it's vital.
The point is to do it, so you have the peace of mind that you've
Right.
done the planning when it was appropriate. We try to do that in a sensitive way, but at the same time, it is important. It's something that a lot of people don't want to talk about. They don't want to talk about death and dying, but we talk about it every day, and it's part of our job, and it's to try to explain to folks why it's so important to do this stuff. Just one comment on the long-term care. Again, back to what Becky said at the beginning, people have choices, and you have to, everybody's not going to fit into the same policy, they're not going to fit into the same approach. If you have enough funds to take care of yourself, that's wonderful. You can self-insure, basically. If you don't have sufficient funds to do that, then you have to make some decisions. Is it more important to you to have the peace of mind that you might have long-term care available to you? Well, if you do, then you're going to have to pay the premium, and the premium is going to be something you're going to pay out of your pocket today, which means less money to do things today than you want to. So there is that cost-benefit
Risk analysis
of paying for something that you may need in the future. Again, back to your point at the beginning of the show, if you know when you're going to die, or you know how you're going to die, I can tell you exactly what you should do.
Sure.
Yeah.
If you're going to suddenly die of a heart attack, you may have paid for long-term care insurance you don't need. If you're going to have a long-term illness that takes you 3-4 years, then you're going to need that, because otherwise your other sources of funds are going to be used up taking care of you in those circumstances.
Which actually is a nice way to segue into kind of Title 19. So what happens when you do run out of assets to pay for your care, or you haven't engaged a long-term care insurance plan, and so then your only viable option really becomes Title 19, which is public assistance, a needs-based benefit. And you know, there's tremendous asset requirements and strict requirements that are kind of draconian, but very, very strict in their application. And we used to be able to, we used to have great flexibility in Title 19 planning, meaning that we could actually take your asset picture and kind of manipulate it and look at it and do formulas and stuff that we could actually make you eligible at a certain point in Title 19. And then back in 2005, President Bush in Congress enacted the Deficit Reduction Act, which was the broadest, widespread sweeping changes to Medicaid that we had seen in nearly a decade, and really changed the face of what you can do in terms of Title 19 planning. So what you used to be able to hear stories about, oh, I'll just gift, you know, quit claim my house over to my 3 kids and outlive the look-back period, that's much harder to do with these changes to the Deficit Reduction Act. So Title 19 planning isn't a great viable option. It can still be done in certain instances, but again, I would stress, just the same way that we stress that talking to an insurer who really specializes or focuses on long-term care insurance, you really want to talk to somebody who really understands Title 19 and the idiosyncrasies and the pitfalls, because you could really get yourself into a world of problems if you don't do proper planning.
Oh my. So if you're just joining us with this heavy discussion, I'm talking to Rebecca Iannantuoni, an associate at the law firm of Pitney, and to a partner at the firm, Dane Dudley, and we are talking about those concepts commonly put under an umbrella called elder law, but it's not for elderly people at all. Certainly it would be good to start. Gosh, I can't even imagine like planning when you're so young. It's so hard for for young people to even think about retirement, much less long-term care. But but the more and more you're talking, the more I'm realizing this is very critical things you have to plan for. So I'm going to segue for a second here. Dane, another big topic. Try to make it small for me.
Okay.
Estate planning.
Okay. Estate planning, I think, boils down to probably 3 major issues. Okay. The first is picking people who you trust to perform certain things for you after you've passed away or while you're alive. And estate planning encompasses the incapacity planning we talked at the beginning of the show. Who's going to take care of you if you can't take care of yourself medically and financially. It also encompasses what happens after you've passed away. Who's going to be in charge of collecting your assets and paying your expenses and paying taxes and giving your money to the people you want to give it to. So that's the trust piece. Who do you trust to run the show when you're not around to run it yourself? The second piece is who gets the property. Where does your money go when you've passed away? And how does it go? Does it go to charity? Does it go to family members? Does it go to them outright? Does it go into a trust to take care of them? So that's the property distribution part of it. And then the third part of it is the tax issue. And just to make it sort of a big picture idea, typically folks have to consider all the assets that they own, so cash, stock, bonds, houses, real estate, retirement accounts, insurance that they own, all those things they put on their balance sheet and add it up. And in Connecticut, right now, if you have $2 million or less in your own name, you can leave that to whoever you want to. You can leave it give it away during lifetime or at death and not have to pay any Connecticut tax. On the federal side, you can give up to $1 million away while you're alive, or up to $3.5 million total when you die, again, without any tax. There's a separate rule talking about spouses. If you leave property to your spouse, you can leave an unlimited amount of money to your husband or wife, okay, without any federal tax issue. There might be a tax at the second death, but none at the first death. So let me give you a simple example.
Okay.
I have $5 million, and I leave it all to my spouse. There will be no tax when I die. But if my spouse still has $5 million when she dies, there will probably be a tax, because the Connecticut exemption, if it's only $2 million, the estate will have to pay tax on everything over $2 million. And if she has $5 million, and there's a federal estate exemption of $3.5 million. There'll be an estate tax on the amount over $3.5 million. Okay?
So you just spend it down, right?
Well, you have all sorts of planning opportunities to give it away during your lifetime, or leave some of it to charity, or to do special kinds of planning techniques, which I think we can't really cover today, but
right.
There's all sorts of planning ways to get around, minimizing the tax bite when you pass away. But that is the third part of the planning, is how do I avoid taxes to the extent I can, both Connecticut estate tax, federal estate tax, potentially income tax issues that come along with those types of distributions. So those are the three elements of planning that people have to worry about. If folks find themselves with less than $2 million, they don't have to worry so much about the tax issue, but they still have to worry about the who gets the money and how do they get it, and who do I trust to run the show. Part of planning.
When you break it down that way, I mean, forget the numbers, the millions, but the idea of who do you trust, what happens to your stuff, and how are the taxes, if any, handled. That's really then what it comes down to.
Sure, and one more thing to throw in there is if you're someone who has children who are under 18, you also have to factor in the issue of who's going to take care of them.
Right.
The whole guardianship issue. So if you have somebody, a married couple who have a 2-year-old, they need to plan on who's going to take care of the 2-year-old if they're not around.
And by the same token, too, one of the other areas that you really do need to consider is special needs planning for children, for a family member with special needs. And the special needs is an umbrella term, for lack of a better term, that encompasses anything from intellectual and physical disabilities through to problems with mental health issues and drug issues and alcohol issues. You could do special planning techniques to grab that entire kind of population of folks that have inabilities to really manage an inheritance on their own.
So if I had a child or a grandchild who had a special need of some type, part of my estate planning could be something that would take care of that child.
What you would do most likely use is an instrument called a special needs trust, and that has the material purpose of a special needs trust is to supplement their needs, and so that if that child is receiving services through, say for example, the child has cerebral palsy and is receiving services through DDS, the Department of Developmental Services, which we also know as DMR. That child is also on Title 19 likely, and receiving an inheritance could be devastating to their eligibility. So, but if it passes from your estate through to a special needs trust, which that child is the beneficiary of, it doesn't impact their eligibility. And moreover, you're allowed to use the money that's in that trust to supplement their needs. So the child could go on a trip to Disney World, or you could, buy them, certain items that they would need, luxury items that they would need that isn't otherwise provided for by their public assistance benefits. So it's a really great planning tool when you have a child or another family member that you really want to use funds to provide for. It's very important to consult somebody who understands it too, because you can defeat the entire purpose of what you're trying to accomplish if you don't do proper planning.
Oh my gosh, I can see that. I can also see there really is such an advantage. There must be such a feel-good feeling when you've faced all of this, made the decisions, get it all in order, and then you just, live your life knowing that things will be taken care of. But I am also feeling that there must be an emotional component to this that is huge, especially this idea of setting up a trust for dealing with children with disabilities of some sort. The emotional component. Let's talk a little bit about that part. How do you, as attorneys who have to deal with this all the time, how do you do it?
Well, I think Becky and I might have slightly different approaches, but it's sort of, first of all, you have to be people who care about people. You have to be a people person,
right.
Because you're dealing with individuals. We're working with families or their personal issues, and they have to trust us to do the right thing.
Right.
And we tend to find out a lot of information about them very early on, not just the financial information, but their family dynamics, how they get along, who has the issues in the family, and they have to trust us to tell us that information so we can help them do their planning appropriately. But it is emotional. We talked about how hard it is to talk about these topics, but once you get someone to focus on it and to agree that they do need to do the work, it's very comforting to them to know that they've put something in place. And I think after the first time, it's easier the next time. So 2 or 3 years goes by and something has changed, a child has moved away, a brother has passed away, someone they've named that they trusted is no longer able to serve. It's easier for them to come back and say, we need to make a slight change to our plan, or we need to tinker with our plan, because we've already had to go through all the tough discussions about who gets the money and who's in charge and what are the special considerations we have for the family.
Speaking of, excuse me, families, is it advisable, not advisable to talk these issues over with children? And if so, when, how?
I think that Dane and I both come from the same point of view on this, which is when you're doing estate planning, it's really a personal thing that you're doing. Your incapacity planning is different. That's definitely something that you should communicate to your loved ones, certainly the people that you've named in the capacities, the fiduciary capacities. But when you're doing your estate planning, those documents can change regularly. They can change anytime a situation changes. You can change in response to it. So it's not something that you want to necessarily sit down around the table and explain the details of. You can certainly say to your family, I've gone to my estate planner and I've done my documents and they are housed in my safety deposit box. But as to what the details say, it's usually not a good idea, because it can start some resentments, especially if you're not being even-handed with all of your children, or if
or you change your mind.
Well, and that's
absolutely,
and that's absolutely, yep, and that's definitely a consideration, And I think one thing that Dane and I do too when we're approaching families, I think, and I don't want to talk for you, but I think we kind of systemically look at what's going on in the family and approach our estate planning from a non-judgmental perspective, and trying to really get at the heart and understanding what the client is trying to accomplish in their estate planning goals.
All right.
And that gives you the direction and kind of takes the emotion out of it for us, in the sense that we have a mission, which is to kind of bring their goals to fruition.
All right. So, Dane, one last question for you. At the very least, I mean, this is a lot of big topics, but at the very least, what documents should an individual have for this estate planning?
Let me say it this way, that the documents that people should at least consider having would be a living will. That's the document that says whether to keep you alive or not if you're in a very bad mental or physical condition.
Okay.
An advanced health care directive, that's the document that helps you decide who's going to make the medical decisions if you can't make them yourself. The living will can be part of that. A financial power of attorney, that would be a document that authorizes someone to take care of your financial affairs if you can't take care of them yourself. A will that directs who takes care of your property and where the property goes. And potentially a trust of some sort. And Rebecca has talked briefly about supplemental needs trust, but there's all sorts of other kinds of trusts as well. But a trust is a way of holding property for the benefit of somebody else, but not giving them complete ownership. Okay, so there's a lot to cover.
There really is, and we'll have to have you back and maybe take one of these topics and explore it in some more depth. So both for Dane Dudley and Rebecca Iannantuoni, thank you both very, very much for coming tonight. And for you in the viewing audience, I say this every week, I mean it sincerely, I do know the value of time. Thank you for spending another evening with me, and do join us again next time. Thank you.
Full Bloom is brought to you in part by the following: